have everyone's attention, please? Task force members, please gather so we can get started.
Good morning. Welcome to our 5th Jails Task Force meeting. We are excited to be meeting here in Lansing and hear from members of the community here in Lansing. I'm going to start with roll call. Lieutenant Governor Gilchrist.
Present.
Dr. Amanda Alexander. Judge Tom Boyd.
Here.
Sheriff Jerry Clayton. Craig DeRoche. Judge Prentice Edwards. William Gutzwiller. Prosecutor DJ Hilson.
Here.
Monica Johnner. Dr. Cheryl Kubiak. Lieutenant Jim Miller.
Present.
Representative Mike Mueller. Takura. Honorable Dana Nessel.
This is Christina Grassi. I'm the Chief Operating Officer for the Department of Attorney General. I'm acting as the Attorney General's proxy today.
Bill Peterson.
Here.
Senator Runstead. Senator Santana.
Present.
James Talon.
Here.
Robert Verheulen. Representative Yancey.
This is Brian Schmidtke. I am our Legislative Director filling in today.
Thank you very much. Do I have a motion to adopt the minutes from the last meeting?
So moved.
Second?
Support.
All in favor? Aye. Thank you. We have a few report outs from task force members and then some introductory remarks from the Lieutenant Governor. So first, Amanda, can you give us a report on the jail visit in Genesee County?
There we go. Better?
Yeah, better.
Excellent, excellent. So good morning again. It was important to me as a task force member that we hear directly from people who are currently incarcerated, and that as part of the task force members went to go visit people who are currently out of jail. And so I'm thankful to the Pew team and to the Genesee County jail staff who made that possible for us to visit the jail in Flint on October 31st. And I'm thankful to Chief Justice McCormick and other members of the task force who were able to go along with us. I'll share some of the key takeaways from our visit, what we learned from discussions with jail staff, and also with a roundtable that we held with people who are incarcerated there. So we were able to see all parts of the jail, the holding cell, where people are first brought to be processed in, the room where people have their video arraignments with the court, housing units, the kitchen space. Early on, we saw the visiting room. The jail has done away with contact visits, so people can come to the visiting area, but they can only do a video visit with their loved one, not actually a contact visit. As we stood in the lobby, the captain and the undersheriff told us statistics about who is locked up there on any given day. That day, 95% of people in the jail were unsentenced. 95%. According to the administrators, the jail is overcrowded 305 days of the year on average, and it's the unadjudicated population that's causing the overcrowding. They estimate that at least 40% of the pretrial population has been incarcerated for over a year. And the record there, the longest time that someone has ever been sitting in the Genesee County Jail awaiting trial was 7.5 years. In our roundtable with incarcerated people there, we met a man who has been awaiting trial for 4 years. He's a father of 4, and he has a 6-year-old son who asked him, "Daddy, when are you coming home?" And he doesn't know what to tell him. Now remember, there are no contact visits at the jail, so he went in when his son was 2, and so he hasn't been able to hold or touch his son in the past 4 years. The captain and undersheriff attribute the overcrowding and lengthy pretrial stays to failures in the court system and a need to process cases much faster. They said the courts had lots of continuances and unplanned cancellations. The captain and undersheriff pointed out that not only does the delay negatively affect those accused, it also hurts victims and witnesses who must continue to come to court and relive difficult experiences. A few more stats. The administrator said that at least 7 in 10 people who are arrested are under the influence of drugs or alcohol when they come in. They also estimated that roughly 50 to 60% of people were struggling with mental health issues. They told us, quote, "This is not a mental hospital, but my officers have to operate like it is one." After the tour, we had the round table with 5 currently incarcerated individuals, both men and women. Some were in on first-time charges, and others had been through the system 10 times or more. And they echoed what we'd heard earlier about the problem with people sitting there for long periods of time awaiting trial. They said lots of people are sitting in the jail without a court date. They said, quote, "It's a very hopeless feeling." Again, one man told us that he'd been there for 4 years awaiting trial. The man next to him had been there waiting over 3 years and had only been to court twice. One man hadn't seen his judge in 2 years. Some said that they don't feel that they have a say in their court proceedings that happen via video. They said it's usually just the prosecutor and their attorney who speak to the judge, and that it's hard to have input when they're on video and not in the same room as their attorney. One man said, "It feels like you're a puppet on the screen." They had suggestions for the task force on how to improve the system, and I want to relay those now to our task force members. They suggested giving lower bonds or releasing people if they're spending long periods of time in jail without a court date. They said that we need more programming for mental health, addiction services, and anger management. They said that there need to be more diversion options for people dealing with substance abuse. One man said his judge had sentenced him to be in the jail only until a drug treatment bed opened up. He said that he thought that he would be transferred soon and that things seemed to be moving fairly quickly, and we asked him, how long had you been there awaiting a bed? And he said 58 days. They also said contact between incarcerated people and their attorneys needs to be improved, and people need more supports when they leave jail to help them not come back. They said, quote, "You go back into the world with nothing, so you have no other choice than to go right back to what you were doing that got you into jail." Finally, they talked about the toll that cash bail takes on families. One person said, "Money bail makes our families choose between buying food, clothes, and medication or bailing us out." It's safe to say that this Genesee County jail visit and the roundtable with people incarcerated there really drove home the importance of the task force's work and how desperately we need to change this system. We cannot continue to be a state that continues to hold people pretrial for 4 years. Finally, I'll add that after the jail visit, several of us from the task force walked across the street to the city administration building, which houses the mayor's office, for a roundtable with Flint residents that was hosted by Safe and Just Michigan. The event was an opportunity for Flint residents to engage with the task force, and it was held in an auditorium in the city administration building. It was pouring rain that day, and the lobby on the way into the auditorium was full of buckets that were catching the rain coming down through the roof. I'll say it was a stark contrast in public spending and priorities. On one side of the street, so much money is being poured into jailing people, while on the other side of the street, residents came out to have their voices heard in a public gathering space in disrepair. Again, I'm honored to be part of this body that has the potential to alleviate so much suffering and to bring about really groundbreaking change. So thank you again.
Thank you, Amanda. Monica, the task force also participated in a community event in Flint after the visit. Can you give us a report on that?
Amanda kind of mentioned that. Is it on? There you go. I don't even think I need one of these. So the goal of our town hall was to give the community a voice to their concern as public members who are impacted by the incarcerated by their incarcerated loved ones, especially those that have not been convicted of anything. Our jails have lost the concept that people are innocent until proven guilty. Yet the people that are sitting in those jails right now are not treated any different than the people that have been convicted. So this is an issue I have had guidance from my peers in my community. In our research in all of the county jails, we found that Michigan has the second highest cost rate for a 15-minute phone call, which is $22. Alabama is the next highest one. This is unacceptable. We found in Genesee that they actually have more reasonable phone rates, but their profits were going to take care of the jail. I mean, you know, so our community's funding the jail, the things that are going on inside the jails, and it wasn't programming. We had testimony about the community commissary prices throughout the state. We found that a quarter ramen noodle in the store goes from anywhere from 85 cents to $1.29 each. I mean, really? A 4.5 ounce of a toothpaste went from $2.50 up to $5 for toothpaste. And when a little one has to support that from the inside of the jails, think about how much the money's being taken from the kids and the people that are in the community. They have to go get another job just to fund somebody that's incarcerated between phone calls and visits and commissary. Another issue that the jail we found out throughout the state is that jails are no longer providing face-to-face contact like they used to do. Now they're doing them on video visitation. And people have to pay for those to see their loved ones. So, you know, I have this in my community, in Ingham County up here in the DHS. This is where we hold our video conference calls with kids. And in the lobby in the DHS, you can see all these little kids screaming, wanting to talk to daddy. I mean, that's unacceptable. In the community where people are walking in and out of the into the DHS building. The community members found concerns about females' lack of personal hygiene, sanitary items, lack of privacy. One person that we talked to shared that the showers literally go off in 1 minute, and you have to wait another 3 minutes for the shower to go back on. I hate to talk about this, but females are only given 5 pads twice a week. And if you're lucky and you got a nice deputy sheriff, you might get more. But if you have somebody that's into that abuse of power conversation, then they have to go without the pads. We had some lengthy conversation about abuse of power in this community in the meeting that we held in the community. And one man shared about how the guards and the police as well we had some racial discrimination and so, like I said, the abuse of power. So it was interesting that our Genesee County told us that they do look at those different kind of things when they have the community, that people have a place that they can go to talk about, share their grievances about that. But you can't do that all over the state. And it was really interesting to me after we left Traverse City. I had so many people contacting me about the abuse of power in the Traverse City jail. They now have a group called the Dirty Traverse City since we left. So, you know, there are things going on in our state with the jail population. And one of the big things that, you know, what really concerned me was the medical treatment inside the jails. And we're hearing all over the state that people aren't getting their medications, especially their blood pressure pills. People are dying while they're in the county jail. So this is something that I hope the task force, I know it's not a big issue for, literally part of the executive order other than it's a constitutional issue, and it does fall under inhumane treatment. So yeah, the community appreciated the opportunity to be able to come in and talk about what they wanted, the issues that they have with the county jail.
Thank you, Monica. Speaker DeRoche, you participated in a faith leaders video meeting. Can you tell us about that?
Yeah, it was a great call. We had, I don't know if we can hear you. Hit the button again. Is it on? Yeah, there you go. Now it's on? We had a couple dozen people there, but we also had several people that could not attend that meeting where we had other conversations. Our outreach was broad to the faith community of multiple faiths, as well as urban, suburban, and rural pastors and advocates and people that work within their church, their synagogue, or within their faith. And their concerns were really threefold. These folks were not the subject matter experts that we get feedback from other areas where the sheriffs talk to other sheriffs, jail administrators have talked to other jail administrators. So they didn't speak to the specifics for this body, but they spoke to their values very clearly. And they believe that the values that they hold dear are not being served well with the current system. The most striking thing in reviewing the slide deck and the numbers that have already been shown to this task force are a very strong feeling that there are too many people that are in the jails, that the jails are being used as a tool rather than working with underlying issues, that the punishments that Michigan is doling out to folks is not proportionate to what the harm that the people that are in the system have caused. And they feel that that's an affront to their values, that justice represents an equal share of retribution or justice for what somebody's done. And it was very clear to the folks in the interactions that that's not taking place in Michigan. Secondly, and very important, is the impression that the system itself is not yielding fruit. I'll use a scriptural term there for you. That the failure rates are extraordinary, and the surprise that the state leaders, thankfully this task force is looking into it, and the state leaders, the governor creating it, are trying to change it, but that people created in the image of God are not being, their underlying issues are not being dealt with, and they're not being put on a pathway to success is very clear to the folks in the faith community that looked at this. And their hope and their prayer is that this task force and the legislature and others that receive it would look at the value of each human life as having dignity and worth, and that those folks that our policies should be restoring those folks rather than pushing them further off of the cliff. And there was a heavy emphasis on not just the impact for those individuals, but also for the children that follow them. Thank you.
Great, thank you. Thank you, Craig, and good morning, task force members. Good morning, members of the public who have chosen to be here with us today in Lansing for this fifth meeting of this task force on county jails and pretrial incarceration. It has been a long and fruitful journey since the executive order was signed by Governor Whitmer in April of this year, which called for the formation of this task force. That was signed in partnership with members of all three branches of government. Yeah.
Remembered me this time?
Yeah, he thinks she says I leave out the judicial branch, but of course I wouldn't do that. This is an important moment, though, as we are now here in today's meeting. We're beginning now to discuss both amongst ourselves as far as subgroups and as far as the full task force and for public consumption today, beginning to look at the beginnings of the process for developing policy recommendations. And for those may remember, we will be, as a task force, presenting recommendations in January of 2020 on how we can reform our criminal justice system in the forms of county jails and the pretrial incarceration system. We are not going to be making those recommendations today. We are not going to be voting on those recommendations today. But what we are doing today is beginning to have this conversation amongst ourselves as a full body about some of the things that our subgroups, which have been looking at, beginning to dive into, beginning to debate amongst ourselves and working toward. Task force members, I encourage you, as you're hearing from what the other subgroups have been discussing, to take a chance to listen and then to respond with things that you want those subgroups to be also taking into consideration. I'm sure that the subgroups and the report outs will be talking about areas where they've already reached consensus or where consensus is possible. We want you to weigh in on the direction of that consensus to ensure that it not only has your personal perspective, but the perspective of all the communities and constituencies that you represent here. But this is an informational exercise for us to begin sharing. It's the beginning of that sharing process, not the end of it. As we move toward our January presentation of recommendations, there will be plenty of opportunities for all of us to weigh in based on our experiences, based on evidence that we have collected, based on the communities that we represent, to be able to ensure that each group and our collective recommendations are something that we ultimately can be proud of. I think it's safe to say that as we've had these meetings throughout the state of Michigan, we have heard the call for reform from the public loud and clear. And all of you have stepped up to do the real work to make sure that the reforms that we propose are responsible, that they're fair, and that they can be effective. And so I appreciate, frankly, everyone agreeing to be part of this journey with us. I appreciate everyone stepping up to now dig into the real meat and potatoes of this process. And I know that all of you and the leadership that you're showing by being part of this task force, that will be evident when we are able to come forward to the public in January with a set of recommendations that we all can be proud to put our names on, and that we all can be proud to advocate for their implementation starting in January of 2020. Did I miss anything?
I don't think so. I want to, what he said. With one thing I'll say again, we are not voting today. This is an opportunity to hear the starting policy conversations that each subgroup is having, and I would encourage those of you who are in other subgroups, when you're offering feedback, to offer big ideas. Remember, when we started this, we said we wanted Michigan to be a national leader. We wanted to make ambitious recommendations, and this is our opportunity to remind each other of those commitments that we made at the very beginning. We're not voting, though, so just please offer feedback and help us move these towards a report that, like the Lieutenant Governor said, in January we will all be proud to say with one voice reflects our recommendations after a lot of hard work. I also want to thank you all for the hard work you've been doing. It's been a lot of time and work in between these task force meetings that the public has seen. I participated in all of the subcommittee meetings yesterday and was incredibly impressed with how hard you all are working. I think it might feel, with the calendar in January approaching quickly, you can start hyperventilating with all the work that's left to do, but from what I saw yesterday, I know you're all up to it. Thank you for what you're doing, and I think we can get started with our first report. We'll start with Lieutenant Miller with a report from your subcommittee.
Good morning. Subgroup A had our first two meetings, and just by a quick show of hands, can I get a representation of who's on Subgroup A? So if you have any questions or concerns along the way, please don't make me your only point of contact. They all have answers as well. In our meeting yesterday, Dr. Alexander visited with us. She's in Subgroup B. She was able to provide her input. The goal of our subgroup is to recommend ways to expand options for alternatives to arrest and jail, such as offense reclassification, citation in lieu of arrest, pre-arrest deflection, post-arrest diversion that preserve the public safety and adhere to research principles. So in the first couple of meetings, we talked about arrest and arrest practices, some pre-arrest deflection and post-arrest diversion practices. So the difference between deflection and diversion: deflection prevents the person from coming to jail. We take them somewhere other than the jail because their true issue isn't necessarily a criminal issue. The diversion is after they've been arrested and they're in the court process. It diverts them from a longer jail stay. Is just a generalized definition there. We've been considering both statutory recommendations and budgetary recommendations. Some of the things that we want to recommend have a zero cost. Some of the things we want to recommend have a substantial cost. So those things have been considered as we go through this process. We've been really basing our question, or our conversations on one question: who should be arrested and when? Some areas that we've come to consensus in this group, and I want to tell you, this is a very diverse group with very diverse opinions, yet we've come to consensus on several topics very quickly. So one of the things we talked about was just reclassifying some of the charges or changing how we deal with them. For example, no operator's license on a person. Currently, that's a misdemeanor. So if you leave your house to go to the grocery store to get a Coke, and you don't have your driver's license on you, and you get pulled over by a police officer, you've committed a misdemeanor. If you don't get pulled over, you still committed the misdemeanor, you just didn't get caught. So it doesn't count. If we reduce non-moving traffic offenses from the misdemeanor category to the civil infraction category, these offenses can be addressed with just a citation or a ticket. This means that there's less cost to the public through the criminal justice system and to the individual. So there's no going to jail, there's no getting your car impounded, there's none of the other things that go along with a misdemeanor arrest. You appear in court, you can pay the ticket if you wish, and you're still afforded the same rights as somebody charged with a misdemeanor, so you can appeal it or have your day in court. We think that some of the fines for civil infractions could and should be reduced, and the person's ability to pay be considered. Some people can't afford a $250 fine without damaging their family. For the vast majority of misdemeanors, arrest should be the exception, not the rule. Currently in the state of Michigan, all misdemeanors are eligible for arrest. If we were to change that process to make it so that law enforcement officers are encouraged to issue a citation instead of arresting somebody, and they're trained to issue the citation as opposed to arrest, so we'd have to change the culture of law enforcement, that this can be done at a much smaller cost. And we can make this arrest the exception to the rule instead of the norm. So there's two sides to this coin. I had a conversation with our command staff one morning, so this is a lieutenant and above in the sheriff's office, while we're having coffee, and I said, so what do you guys think about having the ability for a law enforcement officer, instead of taking somebody to jail, to just issue an appearance citation? That way they don't have to transport that person to jail. Surprisingly to me, they all said, well, that sounds like a great idea. That means that we can keep officers on the street and they can proactively police instead of just having to waste 2 or 3 hours taking somebody to jail. But let's take the other side of that coin. Let's say that you're Jim Miller and you have a suspended license because you're unable to pay your child support. You get arrested and brought to jail while you're on your way to work. Now you've lost a day of work, you potentially lost your job, and now you're unable to support your family, and you may be the sole income for your home. By issuing a citation and having Jim Miller show up for court several weeks later, I don't lose my job, I can still provide an income, my car might get towed, that's an inconvenience, but none of those other negative side effects that create additional problems exist. So we recognize this creates some logistical problems. But the collection of biometric data, fingerprints and mugshots, we haven't quite figured out how that process happens. There's some ideas floating around, but we believe that with some alterations in how we do business, we can make those things happen without having an arrest. So we got a little excited and we jumped into subgroup C's territory. We apologize, but I think this might help you. At least we hope it does. Currently, there are several reasons that an individual's driver's license can be suspended that aren't related to public safety. So, for example, non-payment of a fine can result in a driver's license being suspended. Not paying your child support can result in your driver's license being suspended. It's our opinion that this list of offenses that cause your driver's license to be suspended should be reduced only to be those that involve public safety. So if Jim Miller keeps driving while intoxicated, perhaps we should suspend his driver's license. Otherwise, we have other tools such as a restricted driver's license that would allow me to drive to and from work and take care of my family while not endangering my family. We agree that all law enforcement officers, including jail staff, should have treatment in mental health and crisis response. We're looking at different training models because we don't want to marry ourselves to one specific model as those models develop over time. But we are firm in our opinion that this training needs to exist. We're very interested in recommending that the state dedicate specific funding for pre-arrest deflection and post-arrest diversion options. So this might mean that we expand current funding opportunities when we look at something like a center to take somebody who's in a mental health crisis. A lot of our rural counties, this doesn't exist. If you come to Allegan County, we don't have a center to take you. Sometimes the only option is to take you to jail. So increasing funding to allow these to happen, it exists in all counties, would be very beneficial. We think that the law should provide some guidance on when and how we deflect people from jail and we divert them from jail. Again, we're considering different models such as drop-off centers, mobile crisis teams, co-responder models, but that's topics for future discussions. In our next couple of meetings, we've got some more things we want to talk about: victims' rights and support at the point of law enforcement contact. We don't want to forget about the victims, and additional funding for victim services. Using summonses in place of warrant arrests. So if Jim Miller has a warrant and he has police contact, the officer that makes contact, instead of arresting him, says, you need to contact the court within 10 days. If they fail to contact the court within 10 days, then it can be handled in a different manner. But this will limit traffic in jail. Alternatives to how we handle child support warrants. So we've had an initiative in our county that's really in its infancy, but we're trying it. If you have a child support warrant, an officer will attempt to make contact with you and arrange for you to meet with your caseworker. If you have contact with the law enforcement officer contacts your caseworker and says, can I bring Jim Miller to you to meet and talk about his child support? Then he doesn't need to go to jail, and the problem is resolved. Data sharing between law enforcement and community mental health partners. How do we know if somebody has a mental health concern when we have contact with them as a law enforcement officer? Currently, that information isn't available. And then state incentive funding models for community-based jail alternatives, keeping people out of jail and being productive members of society. So now, members of the task force, I'm looking for your feedback. Is there anything that we missed here? Is there anything that we really need to look at further? Silence is golden.
Okay, I'll play. How about limiting pickup radius on those warrants by classification? So if a pickup radius on a warrant was for money, someone who didn't pay a debt, they didn't show up for the show cause hearing, then there's the warrant. If the pickup radius were limited to 25 miles, the inconvenience to both law enforcement and the defendant would be limited to 25 miles. And then if it were a more serious offense, you could extend the pickup radius on the warrant. So just by classification, statutorily limit the reach, essentially, of the warrant.
That makes sense. And to add some further information there, if you're arrested in Ottawa County for an Allegan County warrant, or let's say Muskegon County for an Allegan County warrant, it could be days before you make it to Allegan County. So if we reduce the pickup radius, that might reduce the amount of time they spend in custody.
So on our warrants, if someone owes us money, we never have it more than 25 miles, so they would never get picked up anyplace else. What would happen is if they get stopped for a speeding ticket, the officer would advise and release. They would say, hey, you owe money in Ingham County, you should deal with that. And then they would let us know they had that contact. Their ability to hold them is limited by the radius written into the law enforcement information network.
Wait, you're saying your warrants already do that?
Mine do.
You just did that yourself?
Yeah, we do that a long time ago. I mean, why do I want someone in Clinton County or Otsego County to bring down somebody who owes me $20? I mean, it doesn't make any sense.
Gotcha, I just didn't know you were already doing that. All right.
Good job. Any other feedback? Anything else that we're missing? Any questions?
Big, ambitious ideas.
I really think that most of them are achievable and at minimal cost, so I'm really proud of the discussions we've had so far. Thank you.
I'll
Amanda.
add something. Yeah, so, and I brought this up yesterday. I'm curious about things that could be decriminalized altogether, so I wouldn't want that to be an option that's off the table or not considered. I also would be concerned of thinking of making things civil infractions as being more of a solution or less of a solution than we hope it is. So we know so many people land in jail ultimately on something that was a civil infraction, so a number of tickets that piled up, fines that they couldn't pay. So I think it's great that we're talking about reducing fines. But we know that people are filling jails because of underlying civil infractions. So I would want us to, not think of that as a catch-all solution and really think about what maybe should be decriminalized altogether, and perhaps things that are civil infractions now not being civil infractions. So getting those off of the books. Things like, we were looking down the list yesterday, and it was a $250 fine for littering. Things like this, for failure to license your dog, for failure to mow your lawn, things like this that maybe don't need to be civil infractions at all. And we'd also talked about diversion being not just law enforcement diversion, but other types of crisis response teams where people don't need to touch the law enforcement system or the court system at all. It could be, maybe there could be a number or dispatch on 911 is trained to be able to say, okay, this sounds like a mental health issue. We're going to send out mental health workers and not get the police involved at all. As a way, I think we're calling it, pre-deflection or preflection or something that would, make sure that people don't at all enter the system unnecessarily.
And perhaps.
Hello?
Yep.
Okay. It's been my experience that many diversion programs, if you don't pay the money up front, you're precluded from participating. So I know that community service is often included in there as mandatory, but again, looking at a person's ability to pay that upfront money and perhaps additional community service in lieu of fines and costs. Because if you're the sole breadwinner and taking that time away or having to decide whether you're going to pay this cost for the diversion or rent, put food in your family's stomach or keep a roof over their head is an impossible position to be in for some folks. So.
Very good feedback. Thank you. Yeah.
Just to add to what my good friend Takura said, in Muskegon County, my office, we have a diversion program. We have two options. A, it's a $200 administrative fee. If you can't pay that, we offer community service in lieu of that fee. So something along those lines. And I'd also be interested in the committee exploring actually giving prosecutors statutory authority to do diversion programs. Currently, we do not have that. And there has been, I'll just say, some friction a little bit between my office and a few members of my bench as a result of that. It would be nice to have actual some law that will back us up in doing these wonderful programs, because I know myself and my colleagues believe that there are individuals who we can eliminate from the criminal justice system altogether. It's just that some of us have been grieved by our bench in the past for doing that. There's a 1948 Attorney General opinion floating out there that talks about paying for nollie process, and that's been thrown in our face a couple of times. And so some statutory authority to do this would be awesome.
That's helpful. Craig?
Yeah, I just wanted to reinforce what DJ just said. I do think that statute would be important here, because a lot of these best practices are being developed informally, and that doesn't help anybody when things go off the rails. What helps is when people are complying within a statutory framework and they're gathering data. So in that one case where things go bad, there's a record of where it has actually improved things. When it's informal, everybody starts pointing fingers, and you can go backward for years by eliminating good programs.
Judge Boyd?
I want to echo Subgroup A's desire to reclassify low-level misdemeanors as civil infractions. As a matter of fact, the Michigan District Judges Association has been for that for years. We've recently adopted a formal list forwarded to the legislature, so we're all on the same page there. Second thing is, while I do think diversion can play a valuable role, we have to be done very carefully, because I'm always concerned the separation of powers is there for a reason, and we are checks and balances on each other's authority. And we have an entire case resolved by one branch of government, by one human being, the county prosecuting attorney. That might be a great thing, and it might be just, sort of ripe for an abuse of power. That's why we have the checks and balances that we have in the system.
Representative Mueller?
And just a quick note on the pickup radius. I do agree. Being former deputy, sometimes I worked in Livingston County, and we would go all the way up to the Upper Peninsula to pick somebody up for, very minute things. However, if we change the pickup radius for law enforcement, that's one thing. But we do have bail bondsmen that their jobs are to pick people up and bring them before the court. So I would think we would want to leave that open. If they want to spend the money to go pick up the person, we do a carve out for them. But for law enforcement, I agree. If you shrink the radius for nonviolent offenses or things like that, it would reduce the burden on law enforcement, because a lot of times you have to use 2 deputies to do a transport. If it's, different counties, and each county has a different policy on that, and you can spend all 8 hours driving up to pick up a warrant for $300. And the second point, I think it's Dr. Hamilton or Dr. Alexander, about the critical incident training or sending people out, mental health issue. When you're dealing with somebody that's mentally ill and they're violent, you have to have some type of police presence there, because it can turn bad really quick. You don't want to send, a lot of times CPS workers, even fire departments, they always have the police come in to make sure the scene's secure first before they have it. If we could, if these people were assigned to go out with them once the scene is secure, that could be something we could consider. But just sending out a group of civilians to a mental health crisis with somebody could put a lot of people at risk, not only the person that's having the crisis, but the workers. If you don't have somebody there that's trained, someone can pull out a gun, a knife, and you don't have the ability to defend yourself, you're going to get yourself in a pretty bad situation.
Dr. Kubiak?
I just want to say that in our meeting yesterday, what the discussion around that was that to train dispatch officers and to have some kind of a system where dispatch identifies a mental health issue and can send trained officers who are trained in mental health. Just because right now dispatch doesn't generally pick up that information or relay that information. So we agree that there's a safety issue, but if there could be a process before sending an officer out, or particularly an officer that doesn't have mental health training, it may decrease or de-escalate the situation even more if you could identify before.
Yes, I agree, and I agree that we should be looking at the training, for the MCOL's training for new officers coming into the program. It's awfully hard to mandate training to existing departments with all the police officers there due to training cost and all of that. But if we start when they first start off in the academies doing it, then they can continue the training in-house and have people in their departments that are trained, or even in the smaller counties, they can do several counties can have like a mental health task force and train individual officers on that, because like in Livingston County, you have people from different agencies, but they'll all respond to a mental health crisis, if need be, from different departments, even if it's not in their jurisdiction.
And I recommend to the sequential intercept mapping model. And what we're talking about is how to get to intercept 0. I see Judge Mack in the audience. I mean, he's written a tremendous paper of the decriminalization of mental illness for the Council of State Court Administrators that talks about getting as much energy at 0 as we can, as opposed to 1, which is when law enforcement's involved. So if we just kind of try and do that community involvement, that intercept before, I think it's both what you're talking about.
Thank you all for your feedback. There's a quote that I heard on a TV show of all places, but I think it's kind of fitting for this group. If you always do what you've always done, you'll always get what you always got. And while what I got had its perks, I want something different now. And I think that we've had this program in place for so long, and it's worked, except it hasn't. And it's time for some change. And I really appreciate what this group is doing. Thank you.
Thank you, Lieutenant Miller. Judge Boyd, who is Group B and what do you think?
Well, first, I have to tell you that it's November, and No Shave November is an opportunity for all of us to think about male cancer check. So male cancers, testicular cancer, colon cancer, prostate cancer, they're all going to kill you, but they're all very treatable with modern science. So you should get your checks, get your loved ones their checks every single year. Oh, back to business. Group B is looking at pretrial release and detention. I'd like to thank the group members, Dr. Alexander, Sheriff Clayton, Speaker DeRoche, Lieutenant Governor Gilchrist, Prosecutor Hilson, Representative Verheulen for their attention, energy, and insights into this. Albert Einstein said if I had 20 days to solve a problem, I would spend 19 days defining that problem. And so we started our work with a 90-minute discussion of defining our problem. What is it we're talking about as it relates to pretrial release and detention? What is the problem? And we came up with these several areas to try and hone in on what the problem is currently with pretrial release and detention. And first is the proper determination of bail in its initial setting and in its review. The questions of bail and bond, how they get set, how they are reviewed. The bottom line is too many people are currently being held. You can't avoid in this conversation the lack of alternatives to incarceration that currently exist. And Lieutenant Miller mentioned those in the arrest segment as well. The concepts of indigency determinations, which need to be more fully developed in the law. The bottom line is today that we have a lack of uniformity. There's subjectivity built into the system. We need to treat every human being as an individual, but at the same time, we need to have uniformity of rule and process. Current constitutional law is changing. The constitutional landscape is moving under our feet, and we have an opportunity because of this group to get out in front of that movement. And the the last note we have in this category is in quotes, and it just simply says, stuff the judge doesn't know. And that is at arraignment, at the first appearance, often the judge or judicial decision maker is woefully ill-informed as it relates to the vital information to make a good release decision. Next is conditions of release, and they need to be tailored to achieve specific goals of bail, and those goals have to be public safety, reasonable assurance of appearance, and we need to avoid them when they're either unnecessary or unaffordable. So as we look at conditions, were they appropriately set? Did they affect release? Were the costs affordable? Again, we're back to lack of sufficient alternatives in many communities. Current constitutional law is going to affect that determination as well. We next come to failure to appear. We've been in these meetings, we've had the Pew folks tell us that the number one reason in Michigan, in the sample at least, that people enter into a jail is because they fail to appear for court. The number one reason to come into a jail is because they fail to appear for a court. Why does this happen? What do we need to do differently to support someone in their responsibility to come to court? There's a current absence of support in most communities. There's an absence of understanding. What are the consequences for a failure to appear? Was the failure to appear willful? Or was it negligent? Was it out of the individual's control? Are they really running? We need more information. We need to deal with bond violations in a thoughtful and informed, individualized manner. Next, detained defendants cannot be allowed to languish. The idea that someone sitting in a county jail for 4 years can't be good information for anybody. Let's assume that this person has made a grievous choice in their life and they're going to end up in the Department of Corrections. Department of Corrections is a much more humane setting than any county jail. So the point is that if that's on the courts, that's on us, and we need to do a better job. You can't have someone languishing in a correctional facility that's inappropriate and not even designed to house someone for that long a period of time. So as it relates to case processing, we need to look at short-term problems, we need to look at long-term problems, we need to look at human and resource components to case processing and how that might be allowing people to languish. It's perhaps a little counterintuitive, but if we're really talking about cash bail and we're really thinking about whether or not we can have cash bail, the states that have gotten rid of cash bail have dramatically expanded their detention net. Detention net is the authority to hold someone without bail. In Michigan, the Michigan Constitution from 1963 gives us our detention net. Roughly, it says you can be held without bail if you're charged with murder, treason, criminal sexual conduct, if you are charged with a violent felony while you are on supervision for a violent felony, if you're charged with a violent felony when you have 2 or more violent felonies within the last, I think it's 10 years, it could be 15, I can't recall. 15? Thanks, Quentin. So if we are to say that we're going to not have cash bail holding people in jail, this goes back to the Traverse City presentation by Mr. Schnecke. We're really making an in and out decision sometimes. If you're arraigning a defendant and he says, I'm in a hurry, could you let me go, I'm gonna go kill her. I've got to go kill her, I've got an appointment, I know where my gun is, I'm gonna go kill her. You have to find a way to not let him do that. And if the detention net is limited to what we have in our current Constitution, and you don't have a $7 million bond to give him, which is what I would do, then you have to find a different way to keep that individual from going and killing her. So that's maybe counterintuitive, but in order to release more people, we may need the power to hold more people. All right, no dirty looks, just quizzical, that's good. Finally, the whole question has to do with resources. As Lieutenant Miller said, there are solutions to these problems that don't cost much or anything, and there are solutions to these problems that are going to be costly, and we as a society need to invest in those solutions. After we look at the problem, we started thinking, where does that leave us? And so we thought we'd approach this from the 30,000-foot level and see what kind of a solution statement would we come up with. Now, this is just sort of general mapping out the destination. And this is what we currently have as our solution statement for this very large problem. We should detain people who present a significant threat to themselves or others and not detain anyone else. Meaningful alternatives to jail and prosecution, where appropriate, must exist and be funded. It is essential to have viable options in place for people who are a threat to themselves. The least restrictive means possible must be used to ensure people's appearance in court. No one should be allowed to languish in a county jail to unnecessary court delays or unnecessary delays of any kind. as Lieutenant Governor Gilchrist said, that this is just the beginning, but our group has come to make some policy recommendations as it relates to a few areas. So the first policy area that we've talked about so far is an automatic or presumptive post-booking pre-arraignment release for low-level offenses. What we have sort of a consensus on our group is that we would support, again, we're still thinking, right? Recommendations for state statutory mechanism establishing automatic or presumed post-booking pre-arraignment release for all low-level offenses. We have the following offenses would be excluded from this release policy: domestic violence misdemeanors. Although we had a very interesting conversation about the fact that we need to expand the current definition of domestic violence in Michigan law. There's a whole bunch of crimes that are missed when we simply say domestic violence is only a forceful, violent, or offensive touching of the person or something closely connected to the person of another, which is current law. There's a lot of other things going on there, and an expansion of that definition would allow that exception to have real meaning and keep victims safe. Aggravated assault, most felonies, and then at the same time, we need to leave the discretion in the hands of sheriffs to hold people who aren't sober, who are under the influence of intoxicating alcohol or drugs, who would immediately return to a melee in the streets. We need to have in the sheriff's power some ability to hold people when they're literally not safe to be returned to the community at that moment. The next policy area we're talking about is the timing of that initial release hearing. This is one of those areas where the constitutional jurisprudence in the country is moving quickly. Today, in most places in Michigan, you could easily be picked up on Friday night and not see a judge or a magistrate until Monday morning. On Thanksgiving, you could get picked up on Wednesday and not see a judge or a magistrate until Monday morning. The current constitutional jurisprudence is really looking like 48 hours. So our group is looking at a recommendation for a state statutory mechanism requiring that an arrested person be seen by a judge within 48 hours after arrest, which reflects existing law in New Jersey, Georgia, Alaska, and other states, and, as I said, the growing consensus within the federal courts. Honestly, we're having a very healthy conversation about the fact that 48 hours may not be the right number, 24 might be the right number, because if you're arraigning people every single day, there may not be reason to do that, to put off for 48 hours. There may be good cause to do that, but there may not be, depending on the situation. The final policy area that we've really put meat on the bones has to do with the presumption of release on personal recognizance. You heard in the solution statement, we think this is something important. So what we talked about is a recommendation of the establishment in state statute of a presumption of pretrial release on personal recognizance with the following or similar language. The court must order the pretrial release of the defendant on personal recognizance or on an unsecured appearance bond, subject to the conditions the defendant will appear as required, will not leave the state without permission of the court, will not commit any crime while released, unless the court makes an individualized determination that the defendant poses significant articulable risk of willful failure to appear, or flight to avoid prosecution, or that the defendant poses a significant articulable risk of causing bodily injury to another person or themselves. Again, as Lieutenant Miller concluded, I'll conclude with things that we're going to come to in future sessions. Conditions of release, how they operate, how they're funded, response to pretrial failure to appear, whether that's negligent, out of the individual's control, willful, or purposeful evasion. Long-term court processing, detention hearings and for those who are detained following the initial appearance, and temporary detention for offenders under the supervision of other jurisdictions, meaning if you're arrested in Wayne and wanted in Washington, we need to find a better way to handle that than is currently operating in some jurisdictions. So, Representative. Your job or mine?
No, you can do it.
Representative.
Regarding the PR bond, I agree with a lot with the PR bond, but I think if you do a PR bond, we should have some type of monetary attached to it. They don't have to pay it, but they know if they don't show up, this is what they are going to be hit with. So then, you get released on a PR bond, but for a misdemeanor, low-level crime, $500, $250 or something, just to have a monetary amount attached to it, because if you're releasing them without any recourse, that could actually make the rates go up. People not showing up, if they say, okay, well, if I don't show back up for court, I'm going to be put in jail for $250, and then you put a little bit of responsibility back on the offender to make sure that, it's just not a free-for-all.
It's an excellent idea. I can tell you, Representative, that my court did this 3 years ago, and our failure to appear rate went down.
And one last thing when it comes to the arraignment, I agree within 48 hours. Or the 24 hours, that's up to the judges. You're going to have to get a judge to come in on a weekend. And so, but I would do carve out for domestic violence. So then the victim has time to maybe plan, because 24 hours after, an assault or a domestic assault, their head's in a whirlwind. They don't know what's up, which way they're going. They have to, a lot of times they get financially, they're put in a hard spot. They don't have access to money. They have to figure out where they're going to go if they're really going to be able to leave the abusive situation. And 24 hours isn't a long enough time for someone to really get their life in order to move on from that. And everyone says there's PPOs, but PPOs are just a piece of paper. If somebody's released within 24 hours, they still haven't had that cooling down period, and they don't care about a PPO. If they feel they were wronged by their significant other or a partner, they're going to get out and they're going to go back and they're going to do something. So the 24-hour, I think you'd have to do, exceptions for, especially for domestic violence.
Thank you, Representative. Great comments. Mr. Nyamfakudza.
Thank you. I think a look at what qualifies as a violent crime or felony, because as you know, an unarmed robbery could really be a retail fraud on steroids. And because of creative charging practices, somebody, again, because the judge may not know everything that there is about the circumstances that bring the person before the court, I think that just blanket ruling that a violent felony of some sort can keep somebody in jail, we need to take a look at what qualifies as something violent, because there may not be any physical contact at all, irrespective. Home invasion, for example, may not involve a touching of any sort. But just a closer look at the definition of what qualifies as violent.
Excellent point. What Mr. Nyamfakudza is mentioning is if you're shoplifting at Myers and the security officer comes and tries to put his or her arm on you and you push them away, that technically can be and often is charged as unarmed robbery rather than the shoplifting of a candy bar. Doctor.
I just want to say similarly, violent offense is usually an exclusionary criteria for getting into mental health diversion programs, when sometimes the violence may be a result of symptoms they're experiencing. So I just want to second that.
Yeah, the legislature, actually, the language in the mental health court statute is better than in the Veterans Court Drug Court statute for that very reason. That's an excellent point. Oh, sorry, yeah.
Yeah, has there been any consideration in terms of pretrial people languishing, the number of judges? I know the state administrator's office keeps recommending reductions. For instance, Wayne County 36th court has lost probably 3 judges in the last decade due to these recommendations. So I don't know, balancing that out based upon caseload. I know that's kind of a legislative area a little bit more, but perhaps, clearer guidelines on how we decide where to reduce judges and add judgeships.
Excellent, thank you. The Supreme Court, through the judicial resource report process, uses tons of science and tons of math to come up with those equations, but there's certainly room for legislative input in that process. You had the final word. Chief.
Yeah, Judge, I agree with Mike in regards to the 24 hours. I would be leery of that, and I'm basing that on the investigation that could occur depending upon the nature of the incident. Some investigations could take up to 2 days to get enough information for the arraignment process, compiling of the reports, interviews, and everything else that had to take place, and 24 hours just, in my opinion, is not adequate enough time for those.
So like, for instance, in Alaska, what they have is 24 hours, but if there's good cause to extend, you extend. And so if law enforcement's investigating a homicide, as Prosecutor Hilson pointed out yesterday, they're going to come in and say, we're not ready to go.
As long as the courts are open to that, that's great.
Can I just ask everybody do your best to speak into your mic. I'm told that people in the back of the room are having a hard time hearing some of you, so when you speak, just do this.
So does that mean I should repeat my speech about male cancer?
Not you, everybody else.
Doctor?
Just a question about the exceptions to release for domestic violence misdemeanors. I'm just wondering if the committee talked about stalking or any other kinds of DV-type crimes.
Yeah, so stalking's definitely on my list. And we didn't actually go into all of them, but thank you. That's a great point. And honestly, that's how we got into the conversation about what a DV is, because the example that I give is a malicious destruction of property, but the fact scenario is he punched out the car window as she's driving away. That's a DV to me, but not under current Michigan law. So the way that Speaker DeRoche suggested we look at that is, well, why don't we make an inclusive definition of what DV really is and call it for what it is, which is the, exertion of force in the imbalance in the power and control relationship in the intimate partner relationship. Define that in a more complicated, complete way, and then put it on the list. So that's actually how we got into that process. Craig?
Yeah, just the idea is rather than have the exclusions be numerous and subjective, so now people are thrown into these buckets, go through and have this task force eventually through the subcommittee recommend that the legislature look to improve and modernize the domestic violence statute itself. So we're being specific as to what we want the exclusion to be for.
And the Lieutenant Governor's reminding me that the states that we looked at as examples often did include stalking on that list. Any other member of subgroup B who'd like to comment? All right. Thank you.
Ahead of schedule, okay. Senator Santana, tell us about Group C.
Okay, thank you, Chairwoman. Just wanted to give Subgroup B the opportunity to chime in at any given time. So who's all a part of Subgroup B? If you could raise your hand. All right, so feel free to chime in at any given time with other added value. We were charged with making sure that we can reduce the jail time and beds that are being used for sentencing. What we have found is that 17% of the individuals admitted to time period spent was more than 82% of the people who were spending time in the jail space was for sentencing or probation and parole violations. So those individuals were spending 82% of their time in jail 30 days or longer. Most people who were admitted to jail time admissions were within a week or so. So what our task or our subgroup was charged with is determining ways in which we can reduce the amount of people who are being sent to jail to spend time 30 days or more, because when you have 82% of those individuals who are sitting there for sentencing, that's a challenge. So one of the key things that we looked at, a lot of people are obviously being charged with driver's license suspensions. They're being submitted to jail because of that reason, or they may not have their licensing. And so one of the things that we came to a consensus collectively is that anything as it pertains to driving, whether it be that they have not the proper registration, or maybe they have maybe they didn't have their driver's license, or maybe they didn't have their insurance documentation at the time, anything that's not dealing with a traffic offense, that those things could be eliminated. So that's something that we looked at and determined as a committee that those things could be considered as a part of driving offense, looking at the driver's license looking at reckless driving and intoxication more so than anything else. I know that subgroup A took a little bit of our steam there, so I'm not going to recant a lot of the things that you already said as it pertains to reclassification of misdemeanors, but that is also an area that we also looked at as a subgroup for non-moving traffic misdemeanors as civil infractions, including operating without a license, as I just mentioned before. This would mean that violations are no longer criminal offenses and you cannot be arrested or sent to jail for those factors, except in the case of contempt of court or non-payment of fines and cost of failure to appear. Those are areas that law enforcement will issue a civil infraction for, which was already mentioned. Sentencing to jail alternatives. We discussed eliminating jail as a sentence for low-level property offenses and for uses of controlled substances. As we all know, we discussed this yesterday in our committee, that marijuana has been legalized in the state of Michigan. And so for use purposes, sometimes people may be stopped, and that may be something that they have in their vehicle. But that is something we discussed. But also we had a discussion around what about other substances, whether or not those individuals would still actually be subject to arrest for other substances outside of marijuana, although that's legalized in the state of Michigan. So that's another area that we looked at as well. We also are still considering other areas that could also be helpful to individuals who are, say, violating their parole or probation. That seems to be a huge issue with individuals who are leaving the Michigan Department of Corrections. Oftentimes what you're finding is that individuals are violating their probation or parole because they don't have the support services in the community in order to help them. So we talked about potentially increasing the community support services to help make sure that individuals do not violate their probation or parole. We look at that as an alternative as well, front-loading the resources that are available to those individuals. So that's another area that we looked at. Do any of the other committee members want to chime in at this time? No? Okay. All right. Other additional policy questions that we considered and still are looking to include, are there any felonies that could be better handled as misdemeanors? This is another area that we looked at as well. Options could also include increasing felony thresholds for some property offenses or reclassifying possession of small amounts of controlled substances, as I just mentioned. We also looked at when should probation be the presumptive sentence instead of jail or felony. So the subgroup considered recommending presumption probation for some intermediate sanction cells, and also in specific sentencing grids, making sure that there's other alternatives. What we discovered is that with the sentencing guidelines, there may not necessarily be the prosecutors and judges obviously are making a determination based off of what is in the actual sentencing guidelines. So we looked at grids F through G to see if there's a way that we could potentially look at some of those areas to reclassify those as misdemeanors. So that was something that we looked at. We were not willing as a committee or a subgroup to touch areas when it came to domestic violence or assault, those areas that were more violent offenses. So we're not willing to reclassify those, but also look at other considerations. Okay. We also looked at technical probation violations. This was an area where we felt that there could be more of a classification or a level depending on what the actual probation violation might have consisted of. So we talked to the probation officer who was there yesterday with us and just tried to figure out whether or not probation officers were considering maybe an individual may have not showed up for their probation check-in or what have you. So could this be something that we classified, looking at a point system, if you will, trying to determine whether or not maybe they had circumstances that were outside their means. Maybe they didn't have transportation in order to get to their check-in at that time. So maybe looking at if they violate so many times, maybe considering, does that warrant them going to jail for those violations? So we try to determine based off of what other states were doing. For example, you had Alaska, I believe, who had a 5-day minimum versus the state of Michigan, we have 30 days, as up to 30 days an individual can spend in jail based off of them violating their probation. So we wanted to make sure that the prosecutors had, or excuse me, probation officers had the ability to make sure that they could potentially, for those individuals who are on probation for longer terms, say, making sure that they have the ability to have a hearing with a judge or without a hearing, determine whether or not if that individual is actually meeting their expectations, that they didn't have to necessarily stay on probation parole or probation for a longer term. We also looked at that as an alternative as well, with looking at individuals who are on probation. Does a time frame merit, say, for example, if they spent maybe 30 days in jail, does a year on probation, does it merit a year on probation? So we wanted to look at potentially mirroring the probation time that they're spending. So maybe perhaps if they spent 30 days in jail, then they would only spend 30 days on probation. Does that make sense? Does everybody understand? Just mirroring that reflection, mirroring that time frame. If they were getting out for felony probation, that could go up to 5 years. So we wanted to see if those time frames are reflective, if they were meeting their expectations in the community within a 90-day, or if they were meeting their expectations going to their substance abuse treatment, getting the supports that they need, then perhaps that means that they could spend lesser time on probation. So we looked at that as well. Oftentimes you have probation officers who are already terminating probations at half those times. All right, so we plan to discuss for future meetings couple things. We're looking at, are there ways to eliminate dead time in jail on parole or violation? So just kind of, as I mentioned before, determining whether or not if those individuals, violated a probation, what putting in a tier system for that, making sure that if the violation merits them spending time in jail, that it's not for a long time. Also, what are the appropriate conditions of probation and parole, including manageable fines and costs? We kind of discussed, sometimes people can't afford to pay for a GPS tracker. They can't afford to pay their fines for restitution. So does it make sense for us to increase those costs to them and making sure that it's manageable for them? Some people they don't have money as it is, so they may be deciding between paying for a grocery bill and meeting that restitution payment. So those are some things that we looked at. And also, how can we prioritize restitutions for victims during the probation process is another area we looked at. Should mandatory minimum periods of jail incarceration be eliminated in some cases? We discussed this, as I mentioned before, but we were not at a point where we came to a consensus on what that time frame looks like, whether we can reduce it from 30 days to something like Alaska, where they're at a 5-day minimum, or 5-day maximum. And also, how can Michigan leverage alternative sentencing practices? So those are some of the key areas that we looked at and also will continue to discuss. And do any of the other subgroup members have anything else to add from our conversations? Yes.
Just with the probation, kind of mirroring the length of probation with, if you commit a 1-year misdemeanor, currently you can be on probation for 2 years.
Can you lean into your mic a little, because they're going to have trouble hearing you. Thank you.
The probation mirroring, if you commit a 1-year misdemeanor, you can go up to 2 years on probation. Part of the reason for probation, though, is to make sure that the people have enough time to pay off their fines and costs and victim restitution and things like that. But looking into it, we should explore the possibilities of, if they complete everything but their fines and costs, do they still have to come in to report for like drug testing and coming in? And the only thing that's preventing them from being discharged is payment of fines. You know, do they still really have to come in every week to drug test and do this if they've been clean for that long a time? So you could still have the 2 years of probation, but the only reason for a violation would be to extend it so that you're able to collect the fines and costs or victim restitution.
Just to provide a little bit of context of the discussion, I think the specific offense we discussed, in addition to a 1-year misdemeanor, was trespass. You can go to jail for up to 30 days, but again, 2 years probation doesn't make sense. We also talked about hunting being, if you don't have a license for the right type of deer, mandatory minimum, 5 days in jail. I had to go to Genesee County for that. Fortunately, worked it out for the gentleman, and he didn't have to spend any time at the Four Seasons there. Also, conditions for somebody on probation should correlate to the offense. If there's no suggestion at all based on the underlying facts that the person was in a subtracted capacity because of some controlled substance, why are they testing? So just some additional context for some of the discussion that we had.
Any questions?
You know, I'm a district court judge, and so it might surprise you to know I know way less about the law than I do the way that opioid use affects dopamine production in the brain. I know less about the law than I do about the CATA schedule that pulls up in front of my court 6 times a day. And I know less about the law than I do about how a batterer tries to use the power and control tactics he used in his intimate partner relationship on my female probation officer by showing up 5 minutes late. This is not easy stuff. If you're going to change to 30 days probation, just don't have it. I can't get him in to meet with somebody in 30 days. So when done right, probation is about behavioral modification. And there's tons of science, and there's tons of different training, and, you know, we're trying to avoid a repeat offense. District court done right is about public safety. We're partners with law enforcement and other community stakeholders to keep our community safe. And if, you know, I know the difference between an Axis 1 disorder and an Axis 2 disorder, and I know which of those have treatment at community mental health and which of those are not treatable in the community. And if I have a limited period of time because of the reason I met them, well, then I'm not going to be able to help change their behavior to keep the community safe. So I guess what I would say is that I understand that some of my colleagues have abused these powers, and we should stop that. And I'm okay with making it against the law that they do that. But at the same time, you can't throw the baby out with the bathwater. You have to be able to see that when done right, we're trying to affect behavioral change. And I'm not really motivated by fines and costs. As a matter of fact, I would recommend to you reading the report of the Trial Court Funding Commission, which talks about the fact that we need to remove the financial incentives from everything we do in the criminal justice arena. And yeah, we let people off probation all the time if they're done with everything and they just owe somebody money. I mean, it's just not, it's not what motivates us. It's important, I'm not saying it's not. And especially if it's restitution to a victim, we're going to pursue it. We have a collections officer. We comply with all the best standards, but it isn't what the criminal justice process is about. So I guess I would just urge a little caution about what it is we're trying to do with probation. Let's curb the excesses. Let's get rid of the punitive punishment with no purpose. But at the same time, let's retain the tools we have to affect behavioral modification. So, you know, honestly, if you've been using an opioid on a regular basis for a very long time, your dopamine production will not go back to normal before 12 months. And so if we're trying to get this person to be able to feel the way nature or however you view the world intended them to, you can't do that in 30 days. And it's not probably going to happen in 6 months. It just depends on a lot of things. And I love doctors. I do what they say. My orders say do what the doctors say. I mean, it's not like I'm making this stuff up. We have the professionals engaged. So I guess we just have to balance what it is we're doing with probation and why. It's not punitive. I tell people at sentencing all the time, okay, you're going to pay fine and cost, you got arrested, you got a lawyer, punishment's over. Now it's time for rehabilitation. Now it's time for what's next in your life. And so we got to be able to kind of retain some of that.
And thank you so much for that comment. I think that's why, as a subcommittee, when we discuss the substance abuse use, I think when we talked about other substances outside of marijuana, that's why we did not come to any consensus on whether or not that probation period would be longer. We were still in the process of deciding on that. So thank you for your comment. I understand where you're coming from.
We did have a great discussion about
did,
the
though.
community, yeah, because I'm a huge advocate for the behavioral stuff. So when we talked about the violations, we said that instead of 3 violations in a period of time so that they can get off of probation early, I said, we need to make sure they had the proper programming consistent with whatever they came to the table with. So, yeah, we had a great conversation about that. So it is definitely a consideration.
Senator, even though it's not part of probation parole, but I think it is the exercise and use of specialty courts. Because really, a specialty court is you're in court, but you're really on probation. And the model that those specialty courts have as it relates to treatment, as it relates to individualized kind of walking through to make sure that this is your last touch with the criminal justice system. I'm a firm believer that model can be probably sped throughout the entire criminal justice system and make a difference. So I'd be interested if your committee might look at that aspect of it. The other thing, and I'm taking every opportunity to promote our exit program. I know the Lieutenant Governor has had a chance to see it. It is, even though it's not necessarily a incarceration program, it is a program that deals with those who are on the verge of going to prison, and they spend the last 90 days of their incarceration leaving the facility, going to our exit program. They're getting job training, college-level courses. At the end of their phases, they're getting employed by our local manufacturers. I would welcome anybody who wants to come and see that and tour it, talk to the participants, see what we're doing in Muskegon County, because there's no other program like it in the entire state. I would invite anybody to do that. Just get a hold of me and we'll establish that. But it's a program that I think I would love this subcommittee to at least take a look at, because it is making some differences locally.
Well, actually, that's what, not to say that, to take away from what you're doing. I talked about your exit program, but we are actually doing it in Ingham County. So I have the specialty courts, I have mental health courts, Swift and Sure, and all that. So we have the wraparound. We have we get the license back. We do all the services. We have apprenticeships. We got construction, welding, all those different kind of things. MSU comes in and does a collaboration. So we got pretty much the same program and it is successful. When you give them the tools to change their behavior, that's what it's all about. I'm huge on cognitive behavior programming. I don't feel like a client can get enough of sitting in and hearing what the light bulb's going off. So yeah, that is huge and it's important.
This is all good feedback, and it sounds to me like, I was there for part of it as well, and there were different discussions about misdemeanor probation and felony probation. Felony probation is 5 years no matter what it is you're convicted of, and it sounded like what we heard yesterday was there are just different ad hoc practices around the state for releasing people from probation early. We learned that the biggest county court in the state doesn't release anybody from felony probation, ever. They have a policy against it. So one of the things I think your committee is looking at is, consistency throughout the state, so people in different parts of the state are treated similarly. But from what I'm hearing today, and I'm sure you'll take this back, it may make sense to think of misdemeanor probation and felony probation as two different sort of things to think about.
Absolutely, thank you. Any other comments?
Just 2 comments. One is about the money, and I agree that we can take money out, but under probation, is it similar to parole where people are, in addition to fines and restitution, paying for their actual supervision, that there's a cost of like $180 a month?
Absolutely.
Okay,
Yeah.
so I wanted to make that, because that's a cost that keeps on incurring. And the second thing, the behavioral modification aspects, I wish we could clone you, Judge Boyd. But I just want people to be cautioned by some of the research that shows that even in the specialty court realm, when you you apply it at lower levels, people end up actually being sanctioned more, that they're under a level of surveillance that ends up with more jail time rather than less jail time. It's not the same for felony, but when we talk about this at district court or felony court, I think we just need to be a little bit cautious about kind of a one-size-fits-all.
Any other comments, subgroup members? Okay. Well, thank you all very much.
Thank you all for those reports. This is helpful. I think each group got some good feedback for our continuing conversations, which are going to be continuing all month. Our lunch will be across the street at 12:15. Do we have time to do one of the afternoon reports right now? Yes? Okay, so we can do, what are we doing now? The victims forever, okay. Yes, is Ann Seymour here? Ann, do you mind if we do your report now? That will give more time this afternoon for public testimony.
1:40 to noon.
Not much to talk about.
Oh, I think, it might not be on. Try and hit the,
Okay. Can y'all hear me? Okay. So nice to see the Joint Task Force all in person. And I want to say I appreciate your discussion from this morning with a lot of focus on crime victims, and the fact that you want to clarify the definition of domestic violence is amazing. I highly recommend it, and you've got great victim advocates here in Michigan, who are ready to help you. My name is Ann Seymour. I've been a national advocate for victims and survivors for 35 years. And when we started the National Center for Victims of Crime in 1986, the very first state I visited was Michigan. So I've had the pleasure and opportunity to spend a lot of time here in your state. I've been working with your Joint Task Force on behalf of the Pew Charitable Trust. I've worked with Pew for about a decade in over half the states on justice reform initiatives. But this is my first state that I'm working on that is specific to pretrial, which is important for a couple of reasons. One is that the pretrial phases of cases, from the time a crime occurs through when there's a criminal court case, can be among the most unsafe time for crime victims and survivors. And unfortunately, it's also when victim services are difficult to access, and in some cases, they're much more limited. So last month, your Joint Task Force hosted 2 roundtables of crime victims and survivors and victim assistance professionals and justice professionals. We did one here in Lansing and one in Detroit metro community. And I want to thank Angie Povolitis and the Michigan Domestic Violence Sexual Assault Prevention and Treatment Board. She's going to talk later this afternoon. They really helped with the outreach to have such outstanding attendance and participation at the roundtables. I want to thank Lieutenant Jim Miller because he provided welcoming remarks at both of the roundtables. He also took us to the Astoria pastry shop, so that was my bonus point. John Pallas, who represented the Attorney General here in Lansing, and Dr. Cheryl Kubiak, who attended the Metro Detroit roundtable. So I think y'all have a copy of the report I wrote. Is that true? Okay, yeah?
I think we do.
Okay,
Yep.
great. So
It's
do you
been-
mind if I
it's
just
been
hit some,
provided to us, yeah.
if I just hit some high points today, knowing that you can read the full report,
Yes.
and also that Angie will be talking about it this afternoon. So we had 10 top discussion points. One that came up was at both roundtables was concerns that the data are overly broad, and that is a quote. With crime victims, there are a lot of underreported crimes, both Michigan and nationally, in particular domestic violence and sexual assault, that just aren't going to be reflected in any of your data. They also noted that sometimes violations of probation are not charged, and so they're not going to show up in the data either. And the suggestion was that we consider augmenting data from prosecutors, shelters, and for all of us who've been in the field a long time, it's just really important to recognize the power of the personal stories crime victims and survivors, and we got a lot of them at the roundtables. I'm going to moosh several discussion points together in the interest of time that just focus on victim services. And what is needed is what we call 360 support for victims and survivors. It should not matter in Michigan who you are or where you live in terms of your access to victim services. That requires sort of a global improved understanding of victim and survivor trauma. A lot of discussion on how that impacts victims' ability or willingness to testify, to report, to cooperate with the criminal justice system. I learned a lot myself personally about the importance of really understanding interrelational crimes, which are often crimes of pattern. I'm going to just read briefly for you what those are. Domestic violence, sexual assault, child exploitation and child pornography, human trafficking, and then alcohol and other drug-related crimes that are often considered non-violent but actually involve violence. So really being able to recognize that victims have unique concerns in those cases. This is not the only state that needs to improve restitution. It is the victim's right that is least implemented, in my opinion, nationally. It was a big thing to improve restitution. I will tell you, my blood boils every time someone says, can the defendant afford to pay restitution? We should be asking, can the victim afford to pay for the losses that result from the crime that was committed against them? And so we have to look at restitution through a different lens. And I will tell you, one of my previous justice reform states, they reinvested their funds to completely change how restitution is managed. So I invite you all to visit Hawaii, seriously, and learn what they have done. They are just so gracious in sharing how they have fixed and improved restitution. And one of the other important things is basic services for crime victims. And those from both of the roundtables include shelters, transitional housing, mental and behavioral health counseling, and conducting needs assessment. We sort of assume that all types of victims need certain things. Every victim is unique. And so when we talk about basic victim services, I want to tell you basic is an understatement. These are services that save lives. I can attest to that. And these are services that in Michigan are going to require additional funding. A couple of reasons. I am from D.C. Please don't hold that against me. Federal funding for victims, the Victims of Crime Act funding, which is the largest source of victim funding across the country, and I believe here in Michigan, is expected to have significant cuts in the next couple of years, like big old cuts, which means less funding from D.C. And some of you probably know that we've had difficulty getting the reauthorization of the Violence Against Women Act even moving in our House and Senate. And so the really big federal funding streams are either going to be reduced or at a standstill, which is going to have a very bad impact on your state. And then I want to just say for a minute, the roundtable that we held in Detroit, we had a lot of victim advocates and survivors who reminded us that the advocates work primarily with African American women of color. And they spoke so eloquently and from the heart about their often mistrust and even fear of law enforcement. And this really has an impact on their capacity to participate in justice processes and then the decisions they make related to everything that we're talking about here today. So we need to have advocates training in historical trauma so they can help survivors make informed and empowered choices that are best for them at that time, at that very moment. And I really ask you to take that to heart because it was a very important thing for me to learn and to understand. And then I just want to talk briefly, because I've heard a little bit of discussion today, and Angie's going to talk later today, about personal protection orders and bond and pretrial release. We heard from several survivors who said their peace of mind came from their perpetrator or alleged perpetrator being put in jail. Jail custody for them was the end all. And we had a lot of discussion about personal protective orders and bond conditions. With PPOs, much discussion about the fact that sometimes it takes a victim survivor longer to get a PPO than it takes for a defendant to be arraigned. And I want you to think about that he or she is out and the victim doesn't even have the protective measure that they need in place. We learned that every single Michigan county processes PPOs differently, which isn't unusual. This happens in a lot of states, but there's sort of not a lack of consistency. And so one of the biggest recommendations is that every single PPO, a no contact provision, be put into the LEIN, the lien, and all bond orders and conditions, including no contact, have to be entered into that so that law enforcement has access consistently to those orders. And the last thing in this is that sometimes violations not sometimes, all the times, violations of PPOs should be handled by prosecutors, and this is going to require additional funding. Right now, the burden is on victims, and I'm one that believes that victims should never have to take that responsibility, that obligation, and things that cost money for a crime that was committed against them. So prosecutors could be able to do that. And finally, there's super strong consensus in both of the roundtables that victims should have input into conditions of bond and be able, if they want to and if they have the capacity, to participate in bond hearings. And some of the folks felt that relational crime defendants should be held in custody until arraignment so the victim has the opportunity to have input into potential release decisions. And I heard your discussion of this morning. These things happen so quickly. Slowing it down just a nudge so that victims might be able to participate is really important. And I want to make a case is that we shouldn't be doing this. We shouldn't consider this a burden, having victims have input and participate. It's actually super helpful because most victims here in Michigan and across the country, they know their defendants. They know the person who harmed them. And so they have a lot of really important information about the defendant's behavior, the defendant's history, and perhaps even the type of help that the defendant needs that won't always show up in your data. And so I encourage you to think about this as an opportunity and not a burden to make sure that victims have that important voice at the table. I urge you, if you haven't read the full report, please do, and I am super happy to answer any questions that you may have this morning. Please.
Are you suggesting that victims should be notified of arraignment so that they can participate? Because as far as I know, there's nothing that really would prevent them, I mean, unless it's an individual judge, from speaking at an arraignment.
Yeah, I'm suggesting that they be notified and they have the opportunity to have input. And victim notification for bond hearings is pretty 2019. It was relatively new a few years back. You know, we can do that now. It's something that we could and should be doing. So yes, and thank you. I didn't realize y'all were all around me. I'm like, whew. Okay, let me get global here. Okay.
I just,
I had a,
Ann, could you just, on the victim notification, I don't remember hearing this in the one that I attended, but the MVine system, would that alert someone of a bond hearing?
If the person is registered and if the program itself is consistent and reliable, it would.
So did you glean that people are being told about MVine and registering for it? Is that consistent?
That did not come up. I can speak nationally because I'm quite familiar with the system.
District Court arraignment's not going to be on MVine.
I'm sorry?
District Court arraignment, Takura, there's no district court, no.
Yeah. So, yeah, it's a lack of consistency and knowledge about Vine, and then the system has to be consistent in its application. Yeah, thank you.
You mentioned, thank you for sharing with us. You mentioned earlier that PPOs take longer than it takes for an individual to get arraigned. On average, what's that time frame for a purpose of protection?
The number that was stated at the Lansing roundtable was 72 hours. Okay. And Angie will be here this afternoon, and that is a great question to have. She will love to talk at length about that with you.
Thank you.
Thank you.
Just a follow-up to her question, is that because of court scheduling issues, or what in your mind, what is the cause of the delay? Why is it 72 hours?
That I do not know the answer to. I could tell you what it is in other states, but may I defer to Angie because she'll have a good answer for you. Thank you.
On this side. Let's go with Speaker DeRoche and then Maryland.
Yeah, I was just going to observe what I was hearing. A lot of the concern that I have is that when we look at victims, our priority is that they come second to the governmental process, you know, in the governmental forms and everything. So when somebody commits a crime, that the government seems to be more concerned with their compliance with what the government requirements are than, you know, than the human being, you know, on the other set. And it's, the government's there to facilitate justice, not to, the government is not the victim of the crime. And so when you say, like you use the word bond, but did you mean bail hearing? You know, bond, like, because it's whether or not the person leaves jail is what many victims would want to speak into, not what a bond would be set at, right?
No, well, the conditions of bond, I think, are super important for victims, again, because many of them know the person who allegedly harmed them. And so to have conditions that will provide information to the justice system, but also, as I started out saying today, victims are at risk in a lot of these cases, and so they want to be able to tell the system what they feel makes them most safe at that time to help them make informed decisions about their own personal safety. And I want to say, nice to see you, Craig, too, but also that it is the state versus the defendant. That is our law. And victims are sometimes on the outside looking in, and that's why these roundtables were pretty amazing to have them on the inside at the table talking.
And I know that's our law. I'm just saying that it's a problem when that's your rationale for how you treat the people, what we wrote the law for. And on the conditions, too, I'm glad you clarified that because I do think that that's very important beyond just the financial, you know, thing is what a lot of people focus on is the bond is how much money, not the conditions of a person being released. So.
Yeah, anything we can do to enhance victim safety, letting them be the people who tell us what that means, because it's not going to be the same for every victim. If you were Lieutenant Miller was at both roundtables, I mean, it was very distinct depending on who the survivor was and what their case was about. Very distinct.
Absolutely. I just wanted to clarify.
Yeah, thank you.
What you meant. Thanks.
Thank you for being here. Two questions. One, I assume that there's no obligation in Michigan to notify the victim of the defendant's arraignment. Do you know, number one, that's true, I assume. Do some counties, some jurisdictions in Michigan, do they make it a practice, and you probably don't know that, to reach out to the victim prior to arraignment or at arraignment?
I think in some jurisdictions they do. I will tell you that victim advocates, both system-based and community-based, it's okay, it's overworked, underpaid. The level of capacity is something that y'all should be concerned about. And I will tell you, as a longtime victim advocate, we, you know, from the court system through corrections, we've gotten that pretty good in most of the states. It's the pretrial area that we need a lot of improvement, and that's why being here in Michigan with you all is just really important.
Are you aware of other states where it's a mandate that the victim be specifically notified and be given an opportunity to speak at arraignment?
Yeah, if you look at all the states that have recently passed Marcy's Law, if you look at a handful of the states that have constitutional amendments for victims, as does Michigan, they do specify that victims have that right. And I'm trying to think, in the Federal Crime Victims' Rights Act, the language is a little more, you could read into it that victims have that right.
At the arraignment stage?
Yeah.
They have the right to be heard under the Van Rigen Mortar Crime Victims' Rights Act and its constitutional provision. There isn't anything in law.
But there's a difference between the right to be heard and the right to, the obligation to be notified, to even be aware of the fact that that defendant will be.
It's very rare that the court knows any way to contact the defendant within the 24 or 48 hours before the arraignment. So the best standards right now, the best practices is a coordinated community response. So in the Lansing area where we sit, CARE, the Capital Area Response Effort, is going to respond with a volunteer to the crime scene when law enforcement's there and to counsel the victim and things like, there's going to be arraignment tomorrow morning, this is how that happens. but that is not required by the law, and it is rare across the state.
Thank you. Thank you.
Thank you.
Yeah, the judge covered that, because like in Livingston County, when you arrest somebody for a domestic assault, you contact, it's called Safe House, and they send victim advocates out. And they also work with the prosecutor's office, so then that way the victim is kept up to speed on every step of the process. You mentioned something about PPOs and lien and conditional bond releases. That is true. In my experience, when you run somebody, district court probation conditions don't show up on lien. So I could run somebody that could be on district court probation, and they're out, or they're not on probation, but they're out on conditional bond or PPO. Let me rephrase that. Out on a PPO, they don't put the conditions of the PPO in lien. You have to contact the jurisdiction of where the PPO was. So I pull someone over in Livingston County, and they have a PPO served out of Genesee County. I have to call up to Genesee County to try to find someone to pull that PPO to find out what the conditions are. And if I don't know what the conditions are, I can't violate this person based on just that they have a PPO, but they can be violating it, but I don't have access. They should be able to, in today's technology, you should be able to scan that into lien so the officers out on the street can see if this person's violating the PPO. And, I mean, we should be able to do that. The other is I agree with the restitution. In Michigan, we're doing these expungement packages, and one of the expungement packages was automatic expungement, where after a certain amount of time, these crimes just come off your record. Well, but restitution doesn't have to be paid. So when you take the human element out of making that decision, I think victims will feel victimized again.
Yeah.
Because you can go in front of, like, Judge Boyd and say, it's been 7 to 10 years since I committed the crime, and judge can say, you know what, Mike, yeah, you've been a model citizen, you've done everything that you needed to do, but you still owe $2,500 to the victim. And if you do automatic, that takes the judge's discretion away. It also limits the victim, because victims can be sympathetic, and you could go in there and say, you know what, he has become a productive member of a society, he's trying to do better.
Right.
I'm going to forgive it this time.
Right.
And then the judge, the victim and the judge have the communication, but when you automatically do it, you take that human element away, and I think we're going down a slippery slope when we do that.
Yeah.
And just like with probation violations in MDOC, the probation officer has to only check twice a year to see if restitution is being paid. They're only mandated to check twice a year. And so and they won't even serve a offender a writ of garnishment. Then when they have to come in to report, someone owes $20,000, which I know a personal case, MDOC will not serve that paperwork for them. So the victim is trying to figure out a way to track down this offender who committed the crime in Roscommon County but moved to Wayne County, is being supervised down there, and they just get roadblocked. So we need to figure out a way to get the victims involved, even if it comes to a probation violation at the circuit court level.
Yeah.
Have them contact and say, in lieu of going to jail, if they can come up with $150 towards the restitution, I will forgive that as a victim because they're making an honest effort.
Just a couple things. Thank you for everything you just said, because I concur. I've had the opportunity to work nationally with the expungement people, and first on my list was don't get rid of restitution as an obligation. And I think that they are listening to me, or if they're not, they will be. I'm not giving up on that. And the other thing with restitution is that we do have some good models from other states, Hawaii being one. The Department of Justice just funded a national center on restitution practices. A lot of states struggle with this, but it's really important to recognize that it is important to victims, and everything you've said is a solution. If we put things together collaboratively in a package like Hawaii did, you can fix it. You can make it better. And I do appreciate your commitment to that. And clearly I'm hearing from all of y'all your commitment to restitution as a core victim's right. And Bill Van Regenmoorder would totally agree with me.
Just to this point, Bill Van Regenmoorder, when I was speaker, was the chair of our judiciary.
He was my earliest mentor in the field, so.
And this is my concern, in the point that I was trying to make earlier, but you put a finer point on it. Most people, if you go 7 to 10 years out, they probably would have paid the government $10,000, $15,000, and the government didn't try to get money to the victim, they tried to get their money. Because guess what? They check that every day. They don't check it twice a year. They check it all the time. The government wants their money, they prioritize themselves over the victim. That's the point that I was trying to make.
That's not how the law works, though, Craig. I mean,
What's that?
in Michigan, of every dollar, 50 cents has to go to the victim.
Yeah.
So that's the current law.
I'm just saying, as far as the collections and where it goes into the funds and how it gets distributed.
I understand, but the victim gets,
There can be
I think it should be 100%, but the current law is 50% of every dollar goes to the victim, not to the government.
And other states that have done this
Thank
have
you.
shifted their law to say that it all goes to the victims first, so that $2,500 is gone at the time that the expungement hearing comes up many years later. And so it's really on the government whether or not they need their money.
I would support that, but I'm just saying that today, it isn't that the government gets their money first.
And I
That's not
appreciate that, Judge.
accurate.
And the best practice in our field is restitution first,
I don't have
split
any
only
problem.
with child support, because that's equally
Honestly, I'm
important.
not going to admit that I ignore the state law, but that is the way we do it where I work.
I love y'all for that. Thank you so much.
Sorry, Chief.
Yeah.
Just real quick on the notification piece, and maybe you got this from talking with some of my colleagues across the state, but our ACT system, our statewide warrant system, has a link to it so that our victim advocates, all they have to do is punch in victims or
Yeah.
victims' families' information, and they get automatic notices sent to
Yeah.
them. So it's not as fast for the arraignment, so I do appreciate
Yeah.
your concerns there. But it does catch pretrial, catches motion hearings, what we call Cobb's hearings, pleas and sentences, and so notification is going out as long as we've got the most current address. That's happening on a routine basis on every single case,
And
misdemeanor or felony.
I want to say thank you for that, because I don't know if y'all know, but you have some good systems in place, and you have some of the best victim assistance professionals. I work in all 50 states in the country right here in Michigan. There's a lot of good going on. I really thank you for reminding me to say that.
Thank you for that, because I have some great women in my office that have worked tirelessly every day to make sure that we're keeping on top of that.
And you all mentioned Bill Van Regenmorter, but he is just a hero to many of us, and he paved the path for some fine advocates here in Michigan for the last, 40 years? Yeah.
So on Senator Santana's point, well, there's a difference between a civil order, which is the personal protection order, which may or may not take 72 hours. I don't know. I'll defer to my brother, Judge Edwards, on that question, because that's a circuit court remedy in a civil matter. What we're talking about in terms of the criminal case where there's a domestic violence charge, that order is going to be placed on at arraignment.
Right.
So that's one of the reasons that domestic violence is held till arraignment under current law. Felonies and domestic violence under current law cannot be subject to an interim bond. They have to be held till arraignment. And the number one reason is because Public Act 53 allows that no contact order as a part of that, and the order also has to go into lien. The order comes from the court at arraignment to law enforcement or the court itself, depending on how you're structured, that has to go into lien. So there isn't a delay as it relates to a criminal case and a criminal no contact order, which is effectively the same thing as a PPO, and all that advocates are going to tell you, a piece of paper is not going to save you. You have to have other tools, which hopefully we'll continue to talk about. But so there isn't a 72-hour delay in a criminal context. That's all I wanted to make sure you.
Thank you. I just want to underscore one thing is that while we're talking about victims here, that many of our community supports have been around domestic violence and sexual assault survivors because of the community agencies. But there were many victims that Ann talked with and that I've talked with who are victims of, family members been murdered or there's been some other kind of tragedy. And the supports for them may differ greatly because we don't generally have the coalition of supports in the community. So they talked a lot about that in terms of the victims' advocates through the prosecutor's office are often very overloaded, and that the families... Always. But because they don't have the counter community supports, that they're often left out and left in the cold sometimes in terms of navigating the case or being questioned or whatever the process is. So I just want to put that out there, that I don't want to leave out those victims of those other crimes. That
I appreciate that, and I will tell you, sort of everywhere in the world, domestic violence and sexual assault victims do. The federal funding is quite a bit more, the infrastructure with coalitions, and so you often have victims of child abuse, neglect, pornography. Thank you for bringing up the homicide family survivors in Detroit, where it was amazing what they were willing to share. And so we need to, when we think of victims, remember that it is a wide range of adult and children, men, women, and how other people identify. That is very, very broad, and thank you for, it's in the report, but thank you for saying that today. And I appreciate you coming to Detroit. Thank you.
All right, and our last question here will be from Judge Edwards.
So in terms of the time frame with the PPO, the 72 hours, this is an assumption, and I'm certainly going to defer to Ms. Povolitis when she gets here to provide specificity, but I would imagine it has something to do with folks not knowing how to go about getting a PPO, know about how to kind of engage with the court system, where to go, how to fill it out, who to talk to, where to get the form, how much to pay, whatever the case may be, and then maybe some backlog with the court in terms of them going through whatever else they have to handle before they get to take a look at the PPO. But my question for you is, do you know anything, can you provide us any insight on the Crime Victims' Right Fund here in Michigan? For all criminal convictions, we are obligated, judges are obligated to assess crime victims' fee, whether there's an actual tangible person that you can touch that you call a victim, or if public is deemed a victim. So I just wanted to know, do you know anything about that fund? And if you do, can you give us some insight into its effectiveness?
I know a bit, but Angie knows a lot, so I'd prefer to defer to her. I will say, in almost every state, such funds exist. And at the federal level, the Crime Victims Fund, which puts forth $1.5 billion a year to victim services, including here in Michigan, comes exclusively from fines against convicted federal offenders. And so that is a standardly accepted way of funding victim services. But may I defer to Angie, because she will have much to say on that.
Thank you all. We will reconvene at 1:30. Thank you very much for joining us today. We appreciate the insight and your report. We will read it in detail. Thank you so much. Lunch for us is available across the street. See you back here at 1:30.